prosecutor there?
No, do you want him?
Yes, because I'm going to make a motion to withdraw.
All right, who do you need? This is not a domestic violence, so I'm assuming Kaplan or Muhammad. We
Yeah,
don't have your
either
client
one of
yet.
them is
There he
fine.
is. There he is.
Let me go through. Neither one of them are on Zoom. I'm good. It's on.
Mr. Noakes, if you know, how long has Mr. Holly been in custody?
I do not know, Your Honor,
How
and
long?
Can you hear me, Your Honor?
I can't now. How long you been in custody?
Sir, I've been in custody in the Department of Corrections since August 1st, July 29th, something around there. However, prior to being in the Department of Corrections, I served a year in the Livingston County Jail.
Okay. One I'm gonna get on Zoom.
Mohammed Jamal, he thought he was on.
Morning, gentlemen. He saw a squirrel. He gets distracted. Somebody will stop him in the hallway.
I totally have. I mean, he's that's the person who can stuff first.
Who's on the iPhone, you know?
I don't know. Ask you. Somebody burned.
Morning, counsel. Is Mohammed in the hallway?
Nope.
All right,
Or is Mr.
I need him on Zoom. None of these, Joe, none of these attorneys got anything ready? Mr. Kaplan, good morning. Same here. All right, Mr. Noakes, your appearance for Mr. Holly.
good morning. May it please this honorable court, William Noakes, P 42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. Richard Holly. Mr. Holly, please tell the judge your name.
My name is Richard Lewis Holly.
Thank you, sir. One of you.
Yep, Stephen Gamble on behalf of the people.
Thank you. Go ahead, Mr. Noakes.
Your Honor, at this time, I'm going to make a motion to withdraw from this case I represented Mr. Holly in a case roughly 3 years ago, and we had differences which almost led to a physical altercation, such that I was allowed to withdraw from that case by Judge Kelly Ramsey. And I don't believe it will be appropriate for me to represent Mr. Holly, and I would ask that I be allowed to withdraw from the case and that a new attorney be appointed forthwith.
Uh,
2 weeks.
Anybody? All right, I can adjourn this 2 weeks and put the request in for another attorney.
Your Honor, may I speak?
Yes, go ahead.
Sir, I'm quite sure that you're well aware of how old this case is. This case is 3 years old. All the information I have on the case, it says I was arraigned on this 9/6/22. I don't remember that, but that's the information I have, and I'm going off of my pre-sentence investigation report from the case that I'm in prison for now. I think that's what it said. I was arraigned in front of Judge Lisa Marie or something
Lisa Martin.
like that.
Correct.
Right. I don't even remember that. But I would like, this is on the record, am I correct?
Yeah.
I would like to assert my rights to a speedy trial related to this case right now on the record. I feel that my rights have already been violated. My rights to a speedy trial have already been violated. And so I'm asserting that right today. And this adjournment, I do not wish to have attributed to me.
Okay. Well, it's
between
not
me
because you didn't ask for it.
Okay,
All right.
okay.
So let's address the speedy trial. Given the
Yes.
fact that you missed an exam date in 2022 and you've been in warrant status for 2.5 years, that ain't gonna fly. So we'll adjourn
I
your
understand.
PCC, sir.
I
You
don't
made a
understand how
request.
you can.
Don't talk over me.
Go ahead.
You made a motion, I just denied it. You want to bring that up with your next attorney and file something formally the prosecutor can deal with, that's fine. In the meantime, we'll adjourn this date 2 weeks out so we can do the paperwork to get another attorney here instead of Mr. Noakes to represent you. Understood?
You said I missed the date. When did I miss the date?
October 12, 2022, 11:45.
October 12th of 2022.
Correct.
You're saying I missed the date, October 10th.
No, October 12th, 2022. That was a preliminary exam scheduled 11:45.
October 12th, you said?
Yeah, and I'm not going to say it again. You get 2 weeks from now, we'll get a PCC date, you'll get a new attorney, we'll see you then. Bond is continued. Enjoy your day. Thanks for coming in, gentlemen. We got anything ready?
Mr. Sullivan?
I'll pull the file, Joe. I don't have a Sullivan file.
No, you have a Lawrence file, Attorney Sullivan.
Oh, thank you. Oh, you said Lawrence for Sullivan,
Yes.
which sounds like attorney for client. Go ahead. I got it, Lawrence. I'll cross it off, Joe. Go ahead, counsel.
Good morning, Judge Andrew Sullivan, PA for 261 Sharon here at Lawrence, who's present on Zoom. Ms. Lawrence, can you unmute yourself and state your name for the record?
Yes, my name is Samira Lawrence.
Thank you.
You're welcome.
What are we doing?
Yes, Judge, I filed a motion on this case. It was dismissed over 2 years ago when complainant was failed to appear for a preliminary exam. My understanding is that the prosecution has not sought to refile those charges, but the record of Ms. Lawrence's arrest continues to hang over her head. She fears that it's going to impact her ability to get a job, to find housing. She just recently learned that it's impacting her credit score. Ms. Lawrence, as I provided in the motion recently.
I have no motion.
Little slot that says motion.
No, what, I usually like to see this before the attorney stands here.
Where you,
Go ahead. When was this? Oh, when he filed it. Shit, I don't remember my name from yesterday. Go ahead, counsel. Go ahead.
Well, but Ms. Lawrence recently graduated with a bachelor's degree in psychology from Western Michigan.
Good for you, Miss Lawrence.
Thank you, sir.
You know, she's not had any further
Yeah.
contacts since this case was dismissed. She cares for two young children, ages 3 and 11. She's working 2 jobs. She's both a substitute teacher as
Get to the ask, because you got me at hello. Get to the ask.
steal the records. I think that Your Honor has authority under Michigan Court Rule 8.119
Okay.
to just steal the records of this arrest. Certainly, again, the prosecution, the statute of limitations is still open. The prosecution wants to refile the charges, they may. But until that point, I think that it's only fair that Ms. Lawrence have a presumption of innocence and have a record sealed.
I've never even had this issue come up.
Judge, the people that judge, I believe when evaluating officer safety during a lawful encounter, their ability to properly assess potential threat an individual poses be impaired based on this motion, that this motion was granted, so we would object. In this specific case, it involves an assault with intent to murder, multiple counts of that, I think 2 to be specific. So based on that, I think officers' ability to assess that individual would be impaired, so we would object on that basis.
Also, just clarify the request, Judge, is to seal the public record. I'm not saying the police can't maintain their own private file on Samira Lawrence and use that to do investigation in the future or to protect themselves from whatever threat they perceive. But this is not something that an employer needs to know about. This is not something that, you know, a credit bureau needs to know about. And so I think the rule requires that this be the least restrictive means. I believe it is the least restrictive means of accomplishing this public interest, not just Samira Lawrence's interest, but a public interest that Samira Lawrence be available to be a counselor to help people who struggle with their mental health as she intends to do with her psychology degree.
Anything else?
Judge, I believe things that I have, which would show her what the charges involved with what the person's charged with are extremely important for public safety. I think it's something they should know. At the end of the day, the defendant still was charged. It was the judge found probable cause when they signed the warrant. And this isn't a situation where the case was dismissed on its merits. Complaining witness, and I wasn't a part of the case a few years ago, but the complaining witness didn't have an opportunity. Well, they did have an opportunity, but they didn't testify, so it wasn't dismissed on its merits. So we would just object, but we ultimately understand it's at the discretion of the court.
Thought Adjourn wants me to, but
Sure, go ahead.
all day, Judge.
Yeah.
But the prosecution and I may disagree about what merits are. Here, the prosecution put a witness on notice that there was a hearing and that they needed to be here in order to substantiate a charge.
Right.
And the witness did not appear to substantiate that charge, and so Ms. Lawrence maintains her presumption of innocence.
Right. Right. So look, what's the difference between somebody that gets in the system because there's an arrest and then further investigation charges are never brought? Isn't it the same situation we'd have here? She's in the system, following her around for life. Isn't that the same scenario?
Yes, Judge, I do believe it.
In both that fictional person and this lady have a presumption of innocence. Motion granted. You got an order? All right. Thank you, gentlemen. It's been a while.